Welcome to Orchestrate All the Things. I'm George Anatiotis and we'll be connecting the dots together. Stories about technology, data, AI, and media and how they flow into each other, shaping our lives.
The EU Parliament just voted to bring the EU AI Act regulation into effect. If GDPR is anything to go by, that's a big deal. Here's what and how it's likely to affect, its blind spots, what happens next, and how you can prepare for it based on what we know.
Thank you, George, for inviting me to this podcast. I'm very happy to be here with you. And as a matter of background, I would say that for a huge chunk of my life, my career, I've been a commercial contracts lawyer. Turned more recently into tech lawyer. Thanks to my second legal education, which I was getting at the University of Edinburgh in 2015 to 2018, and then so eventually went from working for large transnational corporations on their commercial projects to working on technology related projects at Deloitte Legal. Back then I was still in Moscow in Russia, working on those issues with my business clients, advising them on data protection, and in particular European data protection. At that point, we had already GDPR upcoming in the draft, but already by 2018, of course, it was necessary to prepare for whoever was getting ready to enter the European market, let's say, or was going to continue operating on it. So we had done a lot of projects which were data protection related, and then eventually machine learning related projects as well. So here how I came to know more about AI. I mean, thanks to my second legal degree and my practical um, involvement into business projects at that time. And then a little bit later, I got more into the policy side of things, and I started working initially in Russia, but then eventually, more recently, at the Council of Europe on matters related to digital regulation and regulation of artificial intelligence and all things data. And this is what I'm currently still doing, although not at the Council of Europe anymore, because of the political repercussions which happened to all the Russian nationals, uh, last year. And so I'm currently in Strasbourg, working in my private capacity with clients who are interested in making sure that their operations actually comply with the law, and these are usually operations related to machine learning models development, more generally data protection compliance, all these kinds of stuff, and also some policy related issues to the extent they usually are concerned with the upcoming EU AI Act, and all kinds of digital regulation, which is either already in effect or coming up in Europe primarily. And I am also, of course, post regularly on LinkedIn. I have some following there, and I have a newsletter on AI and data and digital policy. And you might have been following me already as well. And I'm sometimes also active on Twitter. Also, we're discussing the issues related to digital policy and primarily AI regulation related nowadays.
Mhm. Okay, well, thanks for the intro. And I think what you do is sort of in the on the intersection of AI practice and data practice and laws and regulations. So that's a sort of rare location to occupy, and I guess that because of that, you must probably have quite a demand, because this is a topic that's on lots of people's and organizations' agendas these days, with the explosion in AI, and particularly generative AI, as they call it, in the last few months. And and I also have to say that this is also how I came across your work as well. So through your LinkedIn presence that you just mentioned, and it's what attracted my attention, and hence I thought that it would be an interesting thing to do to have this conversation. But let's actually take a step back, because based on what you said, I think it may be beneficial to sort of clarify the landscape a little bit, and just start by talking about the relationship between those broad two areas that you already started touching upon, so data and AI, and what do we mean when we actually talk about AI. And I think these are also things that, to some extent at least, are also mentioned in in some of the regulations that you briefly touched upon. So GDPR and the EU AI Act. So to start on my part, I think the best way I could possibly describe that relationship would be, and I know it's a bit unorthodox because I'm going to refer to something that I'm not actually able to show in the podcast, so I'll just have to describe it. But I think it's a well-known image and something that people can actually easily find. So today, when most people talk about AI, what they really mean is machine learning, and actually, even in some cases, a specific subdomain of machine learning called deep learning. And while it's something that I personally don't particularly agree with, I've come to accept it as a fact of life. But I think it's also beneficial that if sometimes we just clarify the boundaries, so to speak. So um, if you want to visualize it, you can think of the broad area of AI as a big set that has one subset, which is machine learning. And then within that subset, you also have a smaller subset, which is deep learning. And the reason why people tend to conflate these categories is because most of what's called AI today actually really refers to machine learning, and typically this deep learning subset of it. And what machine learning and deep learning have in common, they vary greatly in the particular techniques that they apply. But what all of these techniques have in common is the fact that there is great reliance on data. And so basically, the common workflow that people adhere to in order to produce machine learning models, which in turn power machine learning systems and applications, is that they need to find good data sets. They need to clean them, and they need to process them through a certain pipeline, apply different types of processing, different types of algorithms, you may say. And then in the end comes out a model that they may use um, to, to apply new data sets and produce predictions or classifications or whatever it is that the system is designed to do. So in that respect, there is a very direct link between the use of data and data sets and the use of AI systems. So I guess my question for you then is, in your experience and the organizations that you deal with, are those distinctions clear for people? Do they see that relationship?
Well, not always, not necessarily, because it depends on from what viewpoint you are trying to approach this issue. Let's say of understanding what AI may be, may not be, and in particular, in my domain, where I'm most interested in is regulation, where it actually makes sense for policy reasons to apply a more strict technical definition of those kinds of systems, or maybe a definition which would not be necessarily strictly technically accurate, but would cover the kind of systems which concerning or interesting to policymakers in terms of how and what they are willing to regulate. And I think we are having those kinds of discussions around the definition of what, let's say, the policymakers are interested in regulating all the time since the beginning of those dialogues on what we want, let's say, regulate. And there are different schools of thought, I would say, that and the positions on this, I think, differ depending on whether you are coming from an industry side, let's say, or policy side, which would suppose that you might be lobbying for some definition which would be, let's say, more beneficial to your line of business, right? And from the opposite side, you might be coming where you would be thinking about what might be the elements of defining the definition of the AI system which we want to regulate. Maybe we just want to consider it as another product, sometimes a consumer product, sometimes um, a business product, but something which is more relevant for the actual activities which are regulated. And then of course there are then different approaches. And some people would be arguing for, let's say, a narrower definition of the AI, and they would be arguing then they are arguing for including into the scope of this definition only, let's say, the machine learning systems, perhaps, right? And some others might be willing to say that actually, if we are willing to set the requirements for those kinds of systems which are in their on the basis basically kind of systems which automating some processes which originally used to be done by humans, we might be willing to include the rule-based systems like good old-fashioned AI into the scope as well. If we want to regulate AI as a product, as a consumer product, yeah. So it may be more sensible in this sense, and some policymakers would say that to make a definition more broad, But then again, apart from that, there is a concern that we have very different definitions, let's say, adopted by different policymakers in different countries. There might not be a sufficient overlap in what each nation considers AI, and in terms of international commerce, international activities which are now being conducted all over the world, over the internet and other networks. There one might be concern if the definitions are very different from each other. And so we have seen this materialize in the fact that, for example, in the draft EU AI Act, most recently they have come up with the idea to incorporate an OECD definition, right? So the Organization of Economic Development has come up with this definition, I think, in 2019. And yeah, there are elements which the policymakers in Europe consider, yeah, it might be a good one, and it's more or less internationally aligned to an extent, and so they have come up with the idea to use this one definition. And it doesn't mean that it's a perfect approach, but it might make sense from a policy perspective. And just to remind those who are not familiar with the OECD definition, it's basically it says that it's an AI system which is machine-based. So this is one parameter. And then for a given set of human-defined objectives, which is a second criteria, it makes predictions, recommendations, or decisions. This is the third one, influencing real or virtual environments. And that would be a fourth part of the definition. And the fifth one says that AI systems are designed to operate with varying levels of autonomy. So it's not necessarily fully autonomous systems. It might be partially autonomous systems, but that would still qualify for the purposes of this definition. So this five-prong definition of OECD now is incorporated in the future European regulation on AI. And of course, there are others as well. So.
Okay, yeah, thank you. Indeed, I mean, the fact that there's a growing number of regulatory efforts or frameworks being brought into effect is a concern in terms of alignment and obviously definitions, as you pointed out, and that's one of the next topics that I had lined up for discussion, but. Before actually going there and doing a little bit of review of current regulatory efforts, I thought a good place to start would be what we call fundamental rights in terms of, well, initially data and then also AI. And personally, a way I think about it is how these rights and potentially obligations as well apply both to organizations, be it companies or public bodies or whatever else, and on individuals. Because I think that we have this kind of two-layered approach, and I think a good example to start examining that would be GDPR, which is regulation which is probably already known to most people. It's already in effect for a few years, and we already have we already have some experience of how it has played out in practice. So let's start with that.
Yeah, sure. So, of course, there are some provisions in this General Data Protection Regulation, which are directly relevant for the AI systems, and those may relate, of course, let's say, to the legal basis for processing the data, which obviously needed if you want to build any kind of machine learning model. You obviously need data, and you need to obtain them, this data, on some legal basis. This is what GDPR says, and there are different options, and sometimes organizations obtain the personal data, which is often a part of the data set, or the whole data set might be personal data, right? They may obtain this data on the basis of consent, like when they are asking you to agree or not agree with the fact that they are going to use, let's say, your data for machine learning, right? And sometimes this happens. Sometimes they directly ask you whether you are agreeing to that or not, right? But it's not necessarily the only situation, and not the consent is not the only legal basis for processing personal data, let's say. There are others, of course, and there might be considerations which would lead to companies, let's say, using contract as a basis, so incorporating some provisions into the terms and conditions which are, let's say, provided for a certain digital product which we are using, and then in the contract they will provide this right of theirs to use whatever data is being collected, in particular for, let's say, machine learning purposes, right? And sometimes some organizations may argue that they have, let's say, a legitimate interest, which is another legal basis under the GDPR. to collect and process data, and sometimes they organizations would argue that yeah, sometimes they have a legitimate interest in collecting the information, maybe scraping it over the internet, and combining it into data sets, and then eventually training their machine learning models, like we are currently seeing happening with one of many major vendors or developers which operate in the space. And of course everybody is now currently pointing in direction of OpenAI, but there are lots of other companies who are doing pretty much the same, so using web scrape data to train their models. And of course, then comes a question of whether and to what extent it is to legal is it legal to use the data which were web scraped for those purposes, and even if it is legal, so what precautions have to be taken to take into account the interests of those people whose data are being scraped, right? So because some data might not be accurate, and it's a huge possibility for internet scrape data, and sometimes they might not be willing to actually they might not be happy with someone scraping their data and then incorporating them eventually into the machine learning model, which then might spontaneously disclose this information also in connection with some other information which was not maybe directly disclosed. And of course, the models which are being built may make inferences. So on combined pieces of information, they may make an inference about a certain personal factor which was not originally disclosed, but based on the data set, they can say that if A and B is true, then C is true as well, because we have prior history, and statistically it might be the case, right? So, and it's a huge issue potentially in terms of let's say privacy issues, because the people might be really affected, might not be willing to have this information disclosed, and might not be happy of someone using it eventually, and those inferences in particular. I think this is one of the main issues, and very frequently discussed issues with matters relating to GDPR. But of course, there is another thing there which is often being touched, is also governed by GDPR, is automated decisions. If somebody is being made a subject of an automated decision which is affecting his or her rights, right? There are certain requirements in place to make sure that those decisions can be, let's say, in certain circumstances questioned and possibly appealed if there's a legally relevant decision which has been taken, and it affects the rights of a certain person, right? There is this element. So these two elements primarily have been already addressed by GDPR, and the issue is whether the companies are already applying those rules which are in place correctly, right? And they could always be a discussion around that. Yeah, so we have had something for some time already which covers that. And even before GDPR, of course, there was a data protection directive in Europe, and there was and there is a Convention 108 of the Council of Europe, which covers even more countries and relates specifically to automated processing of personal data.
Mhm. Okay, well, I have two points to comment on what you just shared about GDPR. So first, well, legitimate interest is something which is quite vague and quite broadly defined, if you could even claim that such a thing could be defined. I mean, if, for example, I have a company which is in the business of, selling marketing data, for example, I can claim that, well, I do have legitimate interest in scraping, for example, people's contact details and creating a registry and making a business out of that. So there is a sort of conflict there between legitimate interest and, well, personal data rights, let's say. So that's one thing. And another thing that I wanted to touch upon was, well, you mentioned that GDPR already included a provision about people's rights to be informed about any decisions being made that concern them that are somehow automated. And, well, first of all, I have to admit that I didn't know that, but knowing that now, I wonder that how can people actually know in the first place that they have been subjected to this? Is there some provision that covers this as well? If not, then I think it may be a bit hollow in the sense that, well, yes, maybe you have been subjected to some kind of automated decision, but if you never know, you're never going to appeal.
Yeah, sure. Of course, the provisions relating to automated individual decision making, which also includes profiling. So this aspect has been also covered since the inception of GDPR. Uh, there are ways to make these rules work, and one basis for them to make these rules work is actually that there are other rights for the data subject, like every individual whose data are being processed is a data subject, is a how it's called in the data protection regulation. And actually, you and me and everybody else has a right to know whether the company processes his or her information, first of all. And obviously, there are situations where we provide this information to an organization, right? And then we are supposed to know about how our data is being used, right? So when we are providing the information, the regulations require that the data controller, which is the organization which is setting the goals, the purposes for data use, informs us right from the start how it's going to use it and whether it's going to use, let's say, automated decision making, right? So you are supposed to know that in advance when you agree to those let's say provisions which you enter into, if you are entering into a contract with a certain entity, right? Or you may just browse the privacy policy of an organization which you are going to enter into a relationship with. And this way you may be able to identify whether they actually use automated decision making or not, right? But this is in the case when they collect information from you directly. And when they do not do that, but they source their information elsewhere, they actually have to really at the certain step inform you. And this is not related purely to automated decision making, but just generally that they have actually data on file about you, and they are going to use this in this or other way. And so the GDPR also provides the right to access, or right of access to the information about that in particular. So there are some circumstances that when they have to disclose that upfront. Some situations that when having collected the information, and if it's practical, and this is a caveat, they will contact you and inform you that they have started data processing. and sometimes the law does not require that, but requires them to inform you if you are willing to exercise your data access rights. So when you are inquire an organization, they have to tell you about that. And of course, the aspects related to automated decision making is included into the general formula. And basically, what the GDPR, in addition to this general and standard rules which apply in any case, what the GDPR says about automated decision making, it like the data subject has a right not to be subject to this automated processing as long as it's fully automated. So if they are going to use a human in the process, human in the loop, this is wholly another issue in the regulatory sense. And there are also other exceptions, where they have, let's say, collected information on you on the basis of the contract in which you entered. Then, of course, there are caveats and exclusions, and from this general rule. So yeah, there is a certain general rule to ask for your consent for automated decision making, but this general rule has exceptions, and yeah, it's not always that you are asked to consent to this automated decision making, and especially when there is a human involved in the loop, which we assume to normally has to have a role of a fail safe in a certain sense, making sure that if the decision is not fully automated and there is a human in the loop, he or she should really play a role of this fail safe to consider whether the processing is making sense, whether the data processing result is making sense, and so on. So this issue is complicated, but yeah, there are provisions in the act, in the GDPR, which cover that.
Okay, so if I were to summarize, I would say that, well, when you enter into a contractual relationship, or even if you do something much simpler, like, I don't know, sharing your data through a web form, it's good. You should actually, as an individual, read the fine print, read the privacy policy, and then you should probably, if you actually care about what happens with the data, you should probably proactively send a request and inquire about that rather than expect to be notified, because as you just laid out, there are lots of caveats and exceptions, and you may not actually get notified. I just have one quick question before we move on to the next part, which is a review of the AI specific regulations around the world. So you mentioned the human in the loop. So I was wondering, is that something that can actually be inspected and verified by some third party? So if, as an organization, I claim that my processes include a human in the loop, and therefore I'm not obliged to follow certain rules, is there any way for that to be audited?
So there sure could be ways for this to be audited, but the thing is with auditing is if we are calling something auditing, I think the first example which springs to my mind, at least, is the audits which we have for, let's say, financial documentation of public entities, right? We have those rules which require actually the involvement of an independent third party, right? So some auditor is obliged by law really to come and see how the organization is doing financially, in fact, according to the documents, right? And they have documentary audits and so on. And then on the basis of this, they provide assurance to others, other market players, and whoever is interested about the financial information of this company, which is, it says it should be true. Yeah, there is this independent, trusted third party which can, and it actually has to do that step for the benefit of society, basically, and the market more generally, yeah, to come and actually verify what's going on there, right? And so, and to provide assurance. For the AI systems, we don't currently have this general obligation to invite somebody, a really independent third party, to do a similar process, but in respect of the IT systems and AI systems which are involved, right? There is no such obligations. Maybe with the exception of some sectoral specific rules, which may already require that kind of or similar kind of verification. Yeah, there might be processes in place, but they are not universal, and they are not standard to the extent the let's say financial third party auditing is standard on the market today, right? And there are considerations, there are actually discussions about potentially and possibly introducing those requirements, at least to cover some subset of AI systems. And we have, for example, a regulation to that effect, actually, which will soon enter into effect in New York. The New York City has adopted their local law 144, which covers exactly that. They require to conduct third-party independent audits of AI systems, but only a subset of those which are used in basically employment, recruiting operations, and even a subset of those where the policymakers thought that there might be a high risk of, let's say, undesired bias and so on in those systems which are used to pre-screen or pre-select candidates for employment or for promotion and so on. And so they have devised this requirement to have those systems, AI systems, audited by an independent third party. So I would say that, yeah, we already have at least one jurisdiction which has enacted those requirements for independent third-party AI audits. And there are, of course, discussions to consider this in other jurisdictions. But if we, let's say, consider what is being provided in the current, at least, version of the draft EU AI Act, which is going to be in effect hopefully soon in Europe, we don't see those third-party audits, independent audits yet there, although we have conformity assessments. We have conformity assessments there, which are supposed to perform the same role, which usually, or similar role, which the audits do, but there is no requirement for independence. So this is already a big difference. And it's not often even there is a requirement to conduct it with the use of third party, because oftentimes, according to at least the current wording, the text of the act, the companies, it would be sufficient for the companies to do this internal conformity assessment and to verify the system internally. So there is no this general requirement. Although we hear, even if you heard this statement by Sam Altman of OpenAI recently, in some of his public statement, he was arguing for this kind of independent third-party audits, at least again for some really high-stakes systems and which might be potentially influential. So again, not all systems, but yeah, there are discussions to have this in place. And so far, I think the potential to verify independently that the requirements have been met is limited, but in some cases it already exists, and maybe we will see a development of that eventually, because I think, even sometimes it may be in the best interests of the vendor itself, or who supplies the system to its buyers, because if I'm supplying an AI system and trying to convince the vendors, sorry, the buyers to buy it from me, how am I gonna prove that it's really trustworthy, right? Because if it's only my words, why should they trust me really? Because I mean, it's a huge question, especially with systems which are operating in high stakes use cases, right? So it might be for me as a potential, let's say, if I'm let's say if I'm a AI vendor, it might make actually sense for me to proactively inquire and invite some independent third party to do an AI audit for me. So I would be able then to provide this independently conducted assessment report to show you, yeah, that I'm really compliant. So this, I think, has also potential. This kind of voluntary involvement of auditors.
Indeed, and not just for vendors, as you just mentioned, but it could also actually create like like a new market, a market for third-party, independent third-party auditors in the same way, like you described. Such actors already exist and do their work in certain domains, like that are heavily regulated, like finance or healthcare, for example. You could have some similar, in principle at least, markets spring up for AI. I'm guessing that even in the case of this one particular legal framework by the city of New York that you mentioned, that because it's still in its infancy, I guess that probably there are still no provisions for the type of entity that could actually fill in that role. It's probably just generic at this point.
Yeah, it is generic at this point, but I think it will develop. The regulations will develop based on the actual practices, and when the authorities will be able, let's say, to survey the market to see what are the best practices really which are emerging, because nowadays I already see those entities which offer those kinds of services based on sometimes their perception of how an audit independent audit should look like. But of course this is not ideal. Of course this is not how things are done in, let's say, in the financial markets, because there are standards which are set not by the auditor himself or herself, but by the independent organization, and then all auditors have to follow them. So it makes of course much more sense to have independent organization setting the standards, and then all the market players who are willing to say that they are conducting audits, to comply with a unified set of rules. So, which would relate to the audit criteria, the audit procedures, and so on. And just from my experience, I see that yeah, there is a movement in this regard to come up with potentially rules which may be later on adopted by someone. And just I have been recently interested in what is going on in that field, and I saw actually that there are some communities which already working to develop those kinds of frameworks and criteria. And just to note one, I would say there is this For Humanity non-profit organization, which I've recently become a contributor to, which is trying to do exactly this, to come up with, independently drafted criteria, and which, if then later on adopted by some governmental organization or rule-making body, I mean, they could serve as a basis for this future rules, which would then create a framework similar to one which you already have for, let's say, financial audits. So there is some future I can see here.
Okay, so I think that we already kind of have a picture of how maybe different legal frameworks around the world sort of influence each other. So you mentioned, for example, how this new provision in the legislation of the City of New York may actually influence, for example, eventually the EU AI Act. And so, in order to have a better idea of what are the players, so to speak, in terms of regulation in AI worldwide, would you be so kind as to quickly give us like a just a checklist without much analysis of what are the regulations that are either in effect already or being discussed around the world?
Yeah, I will not be maybe very comprehensive because I have primarily an interest in what is going on in the European Union, but to the extent I do know, of course, there is. Apart from what I've already described in Europe, this EU AI Act, and of course there are certain provisions which apply to the AI systems which are embedded in the GDPR and the Digital Services Act, which has been also, receiving much attention recently. Other jurisdictions, of course, are thinking or enacting or thinking about enacting some rules, and we can mention, of course, these examples. Like in China, they have their mostly, I would say, sectoral rules around the AI and some recommendations on trustworthy AI implementations. So, and of course, they are very specific and particular to the political situation in that jurisdiction. And I'm not sure that they may not be they may serve as a global example, but there are some regulations in China, and in particular about around algorithmic recommender systems. So they have set up certain requirements in that regard, and as I said, some trustworthy AI recommendations. And of course, speaking of, I would say, a lighter touch, we would regulate in regulatory sense. We might say that actually, the United States, although they have in some states already, again, regulations on data protection, and there are also some federal acts which also relate to sectoral rules on data use, in terms of using like personal data or personally identifiable information, how they call it, let's say in healthcare, right? There is still no comprehensive federal regulation of neither AI nor personal data use in the United States. So, and more generally, I think the approach so far, maybe it will change, but the approach so far, and with some exceptions, as I said, like for the audits of certain AI systems in one particular, sub part of the United States, generally, so far they have refrain from thoroughly regulating the use of AI and data collection. And of course, you may see that a lot of huge companies which are building AI models and offering services based on AI systems are coming from the United States. So there is sometimes this argument, of course, that is being made that maybe the reason why everything in terms of scaling and coming up with new ideas around AI system is to a large extent is coming right now from the United States, is because of laxer regulations, lower amount of regulatory burden that the companies are facing there, so they are able to scale their AI products more easily without sufficient without maybe a substantial burdens in terms of compliance and regulatory requirements, which might be a necessary thing, or an essential thing for any, let's say, European business which is subject to data protection and data retention requirements and so on. Yeah, there might be, and some would argue that, and so some others, of course, might be arguing in the contrary direction that actually, yeah, if you have this kind of regulation in place, you have some kind of legal certainty which allows you, to plan very like long term, in a long term way, your business activities, and you will be sure that, yeah, there is a certain continuity, and you are at least compliant with the set of regulations which is in place, and it's not going to change that much in the future, right? So arguments can be made both ways, and I think some other jurisdictions might be giving also the examples which would be leaning towards the European or the American side of the regulatory spectrum. So, example, there are certain draft rules on AI and actually data in Canada, so which has not been so far maybe successful in terms of being comprehensive and well received in Canada. But I mean, there is some work, and there is this, the draft law, Artificial Intelligence and Data Act, and of course there are other jurisdictions. And to give you one example which is particular to my own experience, I've recently been involved in drafting the AI regulations for Kyrgyzstan. It's a country in Central Asia, and of course it's a much smaller market as compared, let's say, to the European Union and European Economic Area. And they're actually using the EU AI Act as a model in terms of values and principles. I had to come up with proposals to the parliament and government with some ideas about how there could be certain regulatory act put in place, but which would not be as maybe comprehensive and as extensive, and would not have as much regulatory burden, let's say it frankly, as could be possible, even imaginable, in a larger jurisdiction, so like the European Union. Because if you don't have a lot of subject matter experts, and if you don't have expertise in the regulatory bodies, of course, if you want to regulate such a complex technology, or rather not the technology itself, but the use of technology and some uses of technology like AI, well, you have to consider what you can actually do, what is feasible from the regulatory standpoint, also from the business standpoint, because obviously you would not want to suffocate all those startups which are trying to come up with new innovative products and innovative AI systems. Yeah, and it was an interesting exercise in trying to actually to try to come up with a mini EU act sort
Mhm.
of a sort for a smaller jurisdiction. And yeah, it was an extra interesting experience for me.
Yeah, I'm sure that the people who are behind these initiatives also have some pragmatic way of thinking. So, for example, if a jurisdiction as large with as many subjects and as big a market as the EU is trying to lay out some rules, it has a different kind of weight than a country in isolation, such as Kyrgyzstan, for example, that you just mentioned. So, in the case of Kyrgyzstan, if companies find it hard to comply to the regulation, they may as well say, well, okay, we don't care about this market so much, we're just going to pull out. In the case of EU, even though there have been some reported incidents of companies at least threatening to do that lately in view of the upcoming EU AI Act, it's going to be harder to actually put that in practice. They're going to have to write off a very significant part of the global market, and so that makes it much harder. And the precedent of GDPR shows us that eventually, instead of just having, let's say, two set of operational rules, one for the EU and one for the rest of the world, at least some companies find it easier to just apply the GDPR rules wholesale to their entire global products. And so this is sort of the domino effect that regulation can have. But speaking actually about the EU AI Act and knowing that it's probably the most potentially at least influential, and also that we're close to wrapping up, let's focus on that to cover as the last topic, let's say. And let's try to briefly go through the main principles of what the initial draft of the EU AI Act included, which, according to the best of my knowledge, are laid out on a sort of layered approach. So a distinction of the potential impact of what its AI system may have, and what has changed between that initial draft and the latest draft that was recently approved.
Yeah, of course, we'll not be able to cover like all
Obviously.
aspects. Yeah, but I would say that generally there is an interesting change you may trace, which corresponds in particular to, especially if you take into consideration the recent the two most recent versions, which are the one which the European Parliament has come up with in terms of compromise amendments most recently, and the European Council a little bit earlier, back in December last year. So if you consider what the main changes were there based compared to the European Commission proposal in 2021, is that actually they have started to consider those newer systems which have come actually on the market so far, and they were not considered back then. Let's say in 2021, nobody except for the specialists knew about this transformer technology in terms of machine learning models and large language models. Right, there were some already, but they were not as prominent as right now. And so you may see actually that even already back in December, we already saw the act provisions would already include the idea about some AI systems which might be general purpose, right? Which might serve different purposes, and the original idea of this AI developer knowing very well what the uses of the systems of their systems might be, would not necessarily always hold. Yeah. So and this idea um, came and found its way into the text. And even more recently, if you take a look at this compromise amendments of the European Parliament, we already see this again, the new regulatory new notion of foundation models, right? So something which they are now, at least in the current version of the text, describe as a entity which is different compared to an AI system. So there are different definitions for the foundation models, which are a little bit tautologically defined as AI models, and not necessarily maybe which may not be necessarily very clear to everyone, but still they differentiate those foundation models and the general purpose AI systems, which could be utilizing those foundation models, right? And AI systems more generally. And then of course there are different uses to which those systems may be put, and some of them still are considered high risk, but we already see the tendency to consider that there will not be necessarily always high risk AI systems, but sometimes there will be high risk users of certain systems. And now the vocabulary is changing, is evolving a little bit, and you see those kinds of developments, of course. And there are other interesting points which evolved. We see, for example, that yeah, if a certain AI system is being used in you know uh, in a manner where not the system itself take like an automated decision, or something happens eventually in the real world as a result, but let's say if people or organizations are using those systems in a complementary way, like the way you are using, let's say, writing aid, or grammar correction function in your word processor, right? So you may know, or you may not know, that it contains some kind of AI technology which helps you. But in the end, I mean, you are, let's say, you are drafting something and you are using it for your assistance. And then of course the current text says that it's a different scenario, as opposed to the situation where the system itself, technically, so to say, decides what to do and acts upon certain objects, in even in the real world. And of course this needs to be taken into account from the risk management perspective, because those systems which create real consequences, and especially which are affecting people significantly and their rights, I mean, and they need to be more stringently regulated, as opposed to those which we are using just for our convenience, and in the end we are taking the decisions of what to do with the actual output of those systems, right? So these, I think, the most interesting evolutionary changes which have taken place so far, both with the December text, the Council's proposal, and the European Parliament's proposal more recently.
Mm. Yeah, it's an interesting development because it shows, if nothing else, it shows that the people who are in charge of this draft regulation are at least aware of technological developments and trying to incorporate them as much as possible to this evolving draft. So it would be interesting to see what's the road forward for this particular framework. So what's the time frame and what are the steps of the process until it actually comes into effect? And I'm asking that again in the light of what could potentially change between now and the time that it actually becomes effective, and if there is potentially a path to incorporate any additional amendments.
Yeah, so now I think a lot of people already know that there will be a vote, a plenary vote in the parliament on the text of the compromise amendments, and there is a draft, decision to that effect, which has been made public. So, which is basically a consolidated position of the parliament, and there might be some minor changes to it, some minor, or not very minor, but some discussions around the prohibited uses of AI systems. Let's say there might be discussions about biometrics, meaning not all biometrics, but biometric identification in publicly open places, right? This has been a controversial topic which has divided the parliamentarians so far. So different fractions argue differently in this kind of what actually could be the prohibited uses of certain AI systems. Other than that, I think the parliamentarian part of the text, or the version of the text, has been more or less aligned in between the political fractions. And so, except for this prohibited list of prohibited uses, it's not very likely there will be significant changes in June until this discussion and this adoption of this parliamentarian text. But then we will have this trilogue, which requires the parliament, the council, and the commission to come and discuss their approaches, because there are three different approaches in the end, and they need to be aligned. And if all goes well, as far as I understand, there is a high hope on uh, this act being finalized and aligned, all positions between these three entities, three political entities, aligned by the end of this year. And assuming this is the case, which is not 100%, but it's so far it is likely, we will have a situation where, assuming, let's say, if it's enacted early in next year, there will be a 2-year period, 24-month period for the organizations and all AI providers, AI deployers, to make sure that their activities are in compliance with the future requirements. So there will be this 2-year grace period to prepare. Unfortunately, this is complicated by the fact that there has to be also certain standards which has not yet been enacted, which would be useful for the industry to actually operationalize those requirements which are embedded in the act. Because, as you may or may not know, if there are certain standards, which technical standards set on the European level. It is assumed that if you comply with those AI standards, you comply with those AI regulations, with this AI Act. It's a presumption of compliance. This is a rule right now. I mean, it's not the new rule. It's the usual rule around regulations and technical standards in Europe. And the Commission has asked the Senelec committee to come up with those standards. There has been a requirement to develop those. My only worry is that there is little time to come up with all those standards in the meantime, because it's a really huge chunk of work, different horizontal and sectoral standards which need to be enacted, and that will show organizations how to actually what to do in practice to assume compliance, to ensure compliance with the act. And they're supposed to be in place by 2025 or 26. and we will see if it happens as predicted, as hoped. So this will be 2 or 3 years where we will have to see how it all goes and to prepare ourselves.
Mhm. Okay, just to clarify, what kind of standards are we talking about exactly? So again, to draw the parallel, to try and make some comparison to what we know. So GDPR. In GDPR, to my understanding at least, it basically comes down to a few checkboxes, let's say, like, okay, do you have a CDO role in your organization? Do you have a specific consent compliance forms? Do you have certain processes and certain ways of processing data that you know people about and so on? So in the case of the EU AI Act, what could those standards actually be? Are we talking about, I don't know, technical standards like, I don't know, I'm just thinking out loud here. Maybe you have to store your data in a certain way and process it in a certain way. Are we talking about roles in the organization, processes? What are we talking about exactly?
So there are certain standards which have to be developed in terms of complying with the act, and they are likely to include the requirements that would enable you to set up, let's say, a data governance structure which is envisaged by the EU act, or to set up a risk management system, which is also
Mhm.
envisaged by the act. I mean, of course, it applies to high risk systems or high risk users of AI systems. It's not necessary and not foreseen for lower risk systems.
Right.
But to the extent that it is a requirement for certain systems which are high risk. I mean, there has to be some technical standards to align the approaches, and I don't think there will be overly prescriptive in terms of methods of achieving compliance, but there still has to be some alignment in terms of what we actually need to do if we are a business and we want to set up those structures and make sure that let's say there is some quality management procedure in place. And I think there are some standards already which are available from other standard setting bodies, which could be considered and taken into account when Senelec, this joint technical committee on artificial intelligence, proposes or considers its standards. But they have a lot of work to do themselves as well. So
Mhm. Okay. Well, I'm sure that you will be keeping an eye on that, and it's probably just judging from this conversation, it's probably something for everyone to be keeping an eye out because the actual implementation of the EU AI Act depends on that, and it's not exactly developed at this point, as I
mhm.
gather.
Yeah. So we really need to pay close attention to what Senelec does and how they succeed and how they progress with those standards. Because I mean, at least to everyone who is involved from the industry side in developing or deploying AI systems, I think this is very important.
Thanks for sticking around. For more stories like this, check the link in bio and follow Link Data Orchestration.